Make no mistake, what you are seeing with the Harvey Weinstein case is a symptom of a much larger problem. And Senator Canzoneri Fitzpatrick gave you a little bit of the history of that. We have had a majority in the New York State Senate that has made the people of the state of New York over the course of the last 6 years, has made them less safe, less prosperous, and less free. But they weren't satisfied having complete control over what happens in the state legislature, having control over what happens in the governor's mansion. They needed to go further. And by going further, they needed to infiltrate the courts. And that's exactly what happened with the appointment of Rowan Wilson as Chief Justice of the Court of Appeals. The simple fact is, Hector LaSalle, prior nominee who this conference supported, who the governor supported, wasn't liberal enough, wasn't progressive enough, wasn't pro-criminal enough. And so when we talked about stacking the Judiciary Committee, which was one of the first things that happened, as Senator Canzoneri Fitzpatrick alluded to, by adding 3 additional Democratic members, but only 1 Republican member, when it's supposed to be proportionate representation, is because the one thing the Democrats can do is count. And they counted votes, and they knew they didn't have enough to overturn Hector LaSalle's nomination. So they added a member of the Judiciary Committee. That's the reason, for the process that played out over the next 2 months, that's the reason that Hector LaSalle's nomination was defeated. And now we have Chief Judge Rowan Wilson. The problem, though, is the warnings that we received, that Chief Judge was a progressive, that Chief Judge was soft on crime. His pattern with respect to sexual crimes of his decision-making would rear its ugly head. And that's what you're seeing today. It was more important to the Democratic majorities to have a favorable decision out of the Court of Appeals on their redistricting case, which is what this was all about, that will deal with the sexual violence, the sexual abuse, being soft on crime, the other issues that we're seeing coming out of the Court of Appeals now. So we have a much larger problem with politics here in Albany dominating the conversation, even in the courts, which are supposed to be neutral arbiters standing up for justice for all. We see that not happening. But we have a bigger problem with the process. Rowan Wilson has used the process of vouching in for years, bringing justices from the appellate division to come up when there's a vacancy in certain circumstances on the Court of Appeals so that the court can make a decision with the full bench. But instead of going through a rotation system, instead of using the traditional means of selection, the judges that came up were judges that had made decisions both in the redistricting case as well as in the Harvey Weinstein case that had reached decisions on similar issues previously and had decided the way the chief judge wanted them to be decided. And so the selection process itself is now called into question as to whether the litigants who are coming into the Court of Appeals, depending upon the issue, are going to get a fair hearing and get a fair decision out of the Court of Appeals. We can't stand for the Court of Appeals to be politicized. And so the legislation that we're introducing today, and I'll speak about my bill, which is S-9601, actually limits the ability for justices to be able to recuse themselves. If a justice of the Court of Appeals is going to recuse themselves under existing law, they do not have to provide an explanation in open court. In certain circumstances, they don't have to provide an explanation at all if it's of a personal matter. This legislation will change that. Litigants in the Court of Appeals deserve to know, and the people of the state of New York deserve to know, that the individuals who the legislature, their elected representatives, have confirmed are going to be sitting and going to be hearing the cases that they're assigned to. If they're not, they're entitled to an explanation why. And so under this legislation, anytime a Court of Appeals justice recuses themselves, The reasons for that recusal have to be made in public on the record. Secondly, we are now creating a rotating system among the appellate division judges that if the court is going to vouch in another justice to fill its bench, it must be done from the appellate division, and it must be done on a rotating basis based upon seniority from appellate division justices. This way we don't have a situation where the chief judge of the Court of Appeals is able to cherry pick who they want based upon whether or not they're going to be making decisions that ultimately game the system and cast into doubt the impartiality of the Court of Appeals process.